Good day to each and everyone. I am Sanimi Ampamang, BSHM 3A, and today I'm going to discuss the law on partnership and corporation. For our learning objectives is that we need to differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporators. Identify the requirements and the informations and solutions of partnerships and corporations. So, for the topic I outlined, we have here the law on partnership. We have here the advantages and disadvantages of forming a partnership, classifications of partnerships, forms of partnerships, obligations of the partners, the solutions and winding up of a partnership, order of liquidations for general partnerships, order of liquidations for limited partnerships, law on corporations, advantages of corporate organizations, kinds of corporations, disadvantages of corporate organization, distinctions between partnerships and corporations, bylaws, stock corporations, contents of the articles of incorporations, liability of the board of directors, government requirements in doing business as a partnerships or corporations, requirements for registrations of business under the Bureau of International Revenue, requirements for acquiring a business permit with the city of the municipal mayor. It says that in a high level industry like the tourism sector, it is imperative that it strictly complies with the legal requirements in order to operate as a legitimate business. Startup operations must have a strong foundations, and in order to have a strong foundations, you must start with a strong business organizations. So the laws on partnership and governed by the Civil Code of the Philippines, where the law on corporations is governed by Batas Pambansa Building A68, Corporation Code of the Philippines. So we have here the law on partnerships for the Article 1716. By the contract of partnerships, two or more persons bind themselves to contribute money, property, or industry to have a common fund with the intentions of dividing the profits among themselves. So the essential requisites of a partnerships are: first we have an agreement to contribute money, property, industry to a common fund. This is complied with if this describe a joint revenue where partners or pool resources for a shared goal, and compliance means each party fulfills their their agreed upon contributions. We have each of one of the partners brings or is obliged to bring something to the partnerships, and that which is brought becomes common property. So this means each partner contributes assets to the partnerships, and those assets becomes shared property owned by the partnership as a whole. We also have the intent to divide the profits among themselves. This is complied with if the partnership is established to obtain profits, such as the primary goals of the partnership is to generate profits for the partners involved. We also have the profit must be common to all the parties, and profit or loss must be divided among the partners. So this means all the parties share in the partnership's profits, and any losses are also shared proportionally among the partners. We also have the advantages of forming a partnership. We have here the easy to form, improved growth possibilities, freedom from bureaucracy, and we also have the disadvantages of forming a partnership. We have the instability, difficulty in obtaining large sums of capital. Firm is tied to the acts and judgment of one partner as agent. We also have the difficulty in severing partnership ties. Next is the classifications of partnerships. We also have the according to subject matter, which is the universal partnership, a partnership where all the partners contribute all of their properties to the common fund and speak of no particular purpose or subject matter, as long as the purpose is forming a partnership is to obtain profits and is not contrary to law, morals, public order, and public policy. For the particular partnership, a particular partnership has for its object determine things, their use or fruits, or a specific undertaking, or the exercise of a profession or vocation. For the according to liability, we have the general partnership. It composed of general partners where liabilities extend to their personal properties. For the partnership, it is usually attached the word Ltd or limited at the end of the company name. One formed by two or more persons having members, one or more general partners, and one or more limited partners, where the liability of the latter, the third person, is limited to their capital contributions. We also have the according to durations for partnership for a fixed term is one in which the term of its existence has been agreed upon expressly, as when there is a definite period, or impliedly, as when a particular enterprise or transaction is undertaken. For the forms of partnership, it is a partnership can be in any form, even if not recorded at the Office of the Securities and Exchange Commission, except when it is stipulated when a movable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory of the immovable properties and signed by the parties. Otherwise, the partnership is void. We also have in case of limited partnership, the parties must sign and swear to a certificate which shall state, among others, the name of the partnership, adding the word limited and the character of the business. We also have filed for record the certificate in the Office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirements will only make the partnership a general partnership. So, we have the obligations of the partners. First is we need to where contribution is money or property. Next is where contribution is industry. Obligation of the capitalist partners. Responsibility between partnership and partner. Sharing of profit and loss among partners. Property rights of the partners. Liability of individuals partners to third persons. And liability of the limited partner. The dissolutions and winding up on a partnership. So we have here the law in Article 1830. Dissolution is caused without violations of the agreement between the partners by determinations of definite term or particular undertaking specified in the agreement. You also have the by expressing will of any partner who must act in good faith when no definite term or particular undertaking is specified. We also have by express will of all the partnership partners who have not assigned their interest or suffered them to be charged for their separate debts, either before or after the terminations of any specified term or particular undertaken. We also have by the expulsions of any partner for the business bona fide in accordance with such power conferred by the agreement between the partners. Second, in contraventions of the agreements between the partners where the circumstances do not permit a dissolutions under any other provisions of this article, by the express will of any partner at any time. Third is by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. So for the order of the liquidations for general partnerships, we also have the law in Article 1839 that says that in settling accounts between the partners after dissolutions, the following rules shall be observed subject to any agreement to the contrary. So the liabilities of the partnership shall rank in order of payment as follows. Those owing to creditors others than the partners. So it means this refers to the debts or obligations the partnership owes to individuals or entities outside of the partners themselves. You also have those owing to partners other than for capital and profit. So this refers to debts or obligations the partnership owes to partners, but not for the initial investments or capital or their share of profits. We also have those owing to partners in respect of capital and those owing to partners in respect of profits. So this refers to debts to partnership, also partners for initial investments, capital, and for their share of profits earned by the partnership. So for the order of liquidations for a limited partnership, we have the law of Article 1863. In settling accounts after dissolutions, the liabilities of the partnership shall be entitled to payment in the following orders. So those to creditors in the order of property as provided by the law, except those to limited partners on account of their contributions and to general partners. We also have those to limited partners in respect to their share of the profits and other compensations by way of income of their contributions. We also have those to limited partners in respect to the capital of their contributions and to those general partners than for capital contributions, and those to general partners in respect to profits, and lastly those to general partners in respect to capital. So for the law on corporations, we also have the law on section 2 corporation defined. Corporation is an artificial being created by a person of law having the right of successions. So we also have the advantages of a corporate organization. First is strong separate juridical personality. Second is limited liability to investors. Third is free transferability of units of ownership. And fourth is the centralized management through the board of directors. Fifth is professionalism. Sixth is a year to sell small amounts of stock to raise capital. So we also have the disadvantages of a corporate organization. First is the extensive government regulations. Second is double taxation. Third is activities are limited by the charter and various law. For the corporate liquidations, it says that after the dissolutions of the corporations, it continues to exist as a body corporate, but only for the purpose of enabling it to settle and close its affairs, but not for the purpose of continuing the business for which it was established. The liquidations of a partnership affairs shall be for a period of 3 years. A dissolved corporations cannot extend corporate life during the 3-year liquidation period by amendment of its articles of incorporation extending corporate term. However, if the corporation has a pending case which it filed during the 3-year liquidation period and it is still pending after said period, then the stockholders should meet and transfer all the rights of their actions to the trustee so the so that he can continue the case until its terminations. Finally, it has been held that even after the lapse of the 3-year liquidation period, the officers and directors of the defunct corporations are the proper parties in interest insofar as they may be held personally liable for the unpaid deficiency tax assessment made against the defunct corporations. So I think that's all. Thank you for listening and God bless us all.